Bismillahirrahmanirrahim. Assalamu alaikum jami'ukum. In international arbitration conferences, this slot is called the graveyard slot because by now, after lunch, people have arbitration coming out of their ears and the last thing they want to hear is arbitration. But in mysticism, this is called the 11th hour. And the 11th hour is when the mercy of God is deeper in proportion to our need and understanding being broader. So as Catherine Dixon said, the stress of CARB is on thought leadership. It is appropriate that we combine both the physical and the metaphysical. Ladies and gentlemen, Nasir Sahab, even before I began, has this big sheet of paper saying time's up. So my time is being counted. I will try my best to be very brief. I have, looking at the legal landscape of infrastructure projects in Pakistan, 3 main points. There are, to my mind, 3 phases. Next slide. Next slide. Next slide. The 3 main phases of the first one are the initial contracts. These are when the transactional lawyers start making agreements. Now, this is where the problem starts, but it's not because it's being drafted by transactional lawyers. I wouldn't say that. It is because transactional lawyers are, of course, trying to affect an agreement. That is their main objective. The solution is not that it should be drafted by litigation lawyers because litigation lawyers will never agree on anything. The solution is that we have a combination of both. What happens is at the time of drafting of contracts, especially the arbitration clause is an afterthought, as you've heard earlier in the day. So the first phase is that pre-dispute phase, which is the initial contracts. What you need at the stage of transacting, at the stage of drafting the arbitration clause or the dispute resolution clause is to stress test it. And the stress test is provided by litigation lawyers. In order to make it bulletproof, you have to go to the end before you even begin. That's phase 1. Phase 2 is then what we call, next slide, early dispute resolution. Now, in the Nasir Khan and Javed Shiraz's construction report, they have listed out very usefully many techniques used in infrastructure projects. They will vary from bilateral talks to dispute resolution boards to expert determination, early neutral evaluation. All of these techniques are various techniques to prevent a difference from maturing into a dispute. That's phase 2. In Pakistan, we have the Indus Water Treaty, and those of us who have worked on water and the Indus Water Treaty have seen how even in 1960, and at this point it is relevant to mention, as Javed Uppal Sahab mentioned, that Justice Jawad Hassan's grandfather was an engineer. He was an engineer who also was a part of the drafting of the Indus Water Treaty of 1960. In that treaty, there are 3 stages of dispute resolution. The first is the question. The question is what today we call as early dispute resolution. There is a question that arises through bilateral talks or through mediation or through political will that is resolved between the parties. The second stage is what is called a difference. That's still before the actual full-blown explosion of a dispute. And that determination is when you have experts. So in infrastructure projects, you will have that in the form of a dispute resolution board or an engineer, as we have seen in a number of cases involving the Indus Water Treaty. It is only when the question cannot be resolved as a difference. The difference cannot be resolved, that it then becomes a dispute, and it then goes to phase 3. And that phase 3 is what is called ADR, Alternative Dispute Resolution. And in this is where the real legal landscape of infrastructure projects in Pakistan begins. And this very quickly I will also condense into 4 stages. So this phase 3 of alternative dispute resolution has 4 stages. The first stage is ADR incorporating all of these techniques of early dispute resolution, negotiation, contract formation. All of these are underpinned by laws. And the law is not just the procedural law of arbitration, it is the law of the country. So any dispute, whether it's infrastructure, energy, power, water, it will always be underpinned by the major acts, by the Contract Act, by the Specific Relief Act, by the Limitation Act. So an understanding of this underpinning of law is stage 1. Stage 2 is the application of the arbitration law, when neither the contract law nor supporting institutions like the Trade Dispute Resolution Organization or the Public-Private Partnership Authority institution, when they cannot resolve it, that's when we come to arbitration. And arbitration, the second stage, is where we have failed. And failed not because necessarily the law is bad, but as Justice Asim Hafiz very rightly said, it is because at all the junctions where we can resort to courts in an arbitration, the poor court is dealing with a vacuum because of lack and absence of arbitral institutions. So it's not an all fail and doom and gloom situation, because even before we reformed the Arbitration Act of 1940, there are many steps that can be taken in order to expedite and not frustrate arbitration proceedings once they have begun. Stage 3 is court litigation. So stage 3 is court litigation when the dispute goes to court. And here is where we need, as the construction report says, we don't in Pakistan have technology construction courts. We don't have specialized judges who know construction law, indeed EPC, engineering, procurement, construction law, or arbitration law, in the same way that one has abroad. We also don't have specialized lawyers. We are generalists. One day we are arbitration specialists, the next day we have to do Sharia, inheritance and division of Muslim assets. So here is where we need to focus, because the disputes that come up here are very, very practical. And sometimes they are as simple as a procedure. For example, I had a CPEC client, this is only last week, who had a arbitration award, a CPEC arbitration award in their favor. The first shock that came to them was when they asked me, how long does it take to enforce an arbitration award? And I said, realistically, anywhere between 4 months and 4 years. They couldn't believe it. Secondly, then there are other situations, the situations like, in this case we face, that different high courts of different provinces have different procedures, even for registering a case when it comes to foreign entities. How do you deal with that? That's where you need to know not just the arbitration law, but the rules and orders of the high courts, the contract law, the civil procedure. That's where it needs to be very important. The final stage is the fourth and last one, which is treaty arbitration. Now, most of the construction disputes are classic investments. So they need to be understood by treaties along with the layers of underlying law, arbitration law, court litigation practice, and then finally treaty. So out of the 4 phases, we are a bit weak on 2, we're a bit strong on 2. Like all things in life, the glass is either half full or half empty. But to conclude, as the Quran says, Inna ma'al usri yusra. Inna ma'al usri yusra. After hardship, there is ease. And ease we have seen in Pakistan in the form of reform initiatives taken in the form of commercial courts. All the way back to 2005, when the New York Convention Act 1958 and the Washington Exit Convention Act 1965 were implemented into municipal law, and they began their life in 2011. We have seen it in the training of commercial court judges, in the setting up of commercial courts, and we have seen it in conferences like these, CARB. So we are on the right track. And finally, as Toby Landau QC mentioned this morning, invisible earnings. Ladies and gentlemen, God has blessed Pakistan with tremendous natural resources. Forget whether the New York Convention Act attracts 77% more FDI or not. Forget whether we reform things or not. The truth of the matter is there will always be investment because we will always have resources. So whether we do it or the next generation does it, it will be done. Thank you very much.